Hi, this is Ed Sullivan and Mark O'Berty. We are talking about retaliation. Mark, we get a lot of calls on retaliation, and of course, before someone can be retaliated against, they have to engage in protected activity, what's called protected activity. There's actually two forms of protected activity recognized by the courts. Why don't you explain what they are and how they're important?
Sure, the opposition clause and the participation clause, and that's under Title VII and most other laws. The opposition clause says for someone who opposes alleged discrimination, they have to have two things. One, they have to have a reasonable good faith belief, both objectively and subjectively, that the discrimination is occurring and it's illegal. They don't have to be right. It's not a really high standard, but if the court believes, and there's some cases in our materials, that no, you really had no factual basis at all, you were just making it up out of thin air, well then even if the complaint would otherwise be protected, it's not. So it has to be reasonable and in good faith. In addition, the form of the opposition has to be reasonable. So you will find employees that steal confidential information in the company, let's say payroll information, because they say, aha, this helps prove my discrimination theory, see all the pay and we're getting less. Well, the courts in most cases will say, well, that wasn't reasonable, you went too far with what you did. So even if it was otherwise protected, under the opposition clause, it's not going to be considered protected. On the other hand, the participation clause, that has to do with filing a charge, giving testimony during the EEOC proceeding. Those things, because they tinker with the machinery of Title VII itself, involve a much higher level of protection. So most courts, save the Seventh Circuit, has said that participatory activity is per se protected. It doesn't have to be reasonable. So most courts have said if an employee files an EEOC charge, even if it's in bad faith, even if it's totally unreasonable, the filing of that charge is protected activity the company cannot retaliate against it for, save for the Seventh Circuit. The final point is participatory activity doesn't have to be reasonable, unlike opposition activity. So a case that really illustrates this point, some employees took some confidential information, attached it to a charge of discrimination, sent it to the government. They were then fired because the company said, you took our confidential information, you sent it to the government, you breached our policies. The district court said, aha, that was participatory activity since it involved the filing of a charge. It was absolutely protected. Even if it was unreasonable, the company couldn't retaliate against it for that. So you have opposition, participation, and those are the differences.